apart from being in the Supreme Court, I held the death penalty research project at National Law University, Delhi, where we have interviewed all of India's death row prisoners over the last 2 years, from 2013 to 2015. We have tracked down each of their families, and we've interviewed them, and we've interviewed their defense lawyers in the trial court. The idea of doing this was to understand as to who gets the death penalty in India, what's the socio-economic profile of death row prisoners, and also to understand their experience with the criminal justice system in terms of the police investigation, trial, legal assistance in the appellate court and mercy penalty. So we've done this sort of extensive study, and much of what I'm going to say today is based on that empirical evidence. And it'd be great to sort of have your thoughts on the trends we are seeing. The report is due to be released next week, actually, and so therefore I'm going to try and give you a good sense of what we have found, but I'm not going to be able to give you all the numbers just yet, right? Now, before I get to that study, we did a study of death sentence cases from 2000 to 2015, in a 15-year period, as to what happened with death sentence cases. Now, we found that in this 15-year period, about 1,600 people had been sentenced to death by India's trial courts, by the lowest courts. And then what we did was we traced what happened in each of these cases, right? How many of them, what is the fate of death sentences in trial courts of these 1,600 people, right? Now, as some of you might know that all death sentence cases, when a trial court gives a death sentence, it has to mandatorily go to the High Court for confirmation, except in TADA cases, right? In TADA cases, when the TADA court, that's a trial court, gives death, you can't go to the High Court, you have to go to the Supreme Court. Now that's very problematic, right? Because in cases, like in the Veerappan AIDS cases from Karnataka, the TADA court, they were charged under TADA and they were given life by the TADA court. And when the case went to the Supreme Court, it is the Supreme Court that enhances it to death. And this is very, very rare for the court to do. Apart from it being rare, the problem with it is that now you have nowhere to appeal. Right? So the first time you've been given death is in the Supreme Court and you no longer have an appeal. Right? Further, the problem with this TADA kind of cases plays out, if you look at the caste massacre cases in Bihar, if you compare the Lakshmanpur Bathe case and the Bara massacre case, where in Lakshmanpur Bathe you have Dalits being massacred in the Lakshmanpur Bathe case, and in the Bara massacre you have Dalits being prosecuted and being sentenced to death. Now if you see under these two, if you compare these two cases, one of the stark differences is that the police choose to charge those accused in the Lakshmanpur Bathe case under normal IPC. Right? It's a normal IPC charge. Whereas those charged in the Bara massacre are charged under TADA. Right? Now, that's very important. It's not just a technical difference. It's a very important difference because under TADA, many of your protections have been taken away. Right? And the Supreme Court has upheld the constitutionality of TADA. So you have this very fundamental difference in treatment for very similar kind of offenses. Right? And if we get time, I would like to state my position on these two cases. I think both cases did not deserve the death penalty, either in Lakshmanpur Bathe or the Bara massacre. If you look at the evidence in both cases, is extremely problematic. Anyway, now, so if I may just come back to what happened to these 1,600 people, right? So when when the death sentence of these cases, of these 1,600 people went to the High Court, right? Only 17.5%, right? Only about 252 people. Only that many death sentences were confirmed by the High Court, right? 17.5%. And I've not even reached the Supreme Court stage yet. It's at the High Court, only 17.5% death sentences were confirmed, right? 52% were commuted from death to life, and a further 27% were acquitted. Acquitted, not guilty, right? So here you have 27% going from being given the death sentence by the trial court to being completely acquitted by the High Court, right? So I said 252 people, that 17% were given were confirmed. The death was confirmed in the High Court. So what happened to these 252 people in the Supreme Court, right? Amongst these 252 people, right, only 71 were confirmed by the Supreme Court. A further 115 were commuted, their death sentence was again taken away and given life. And a further 22 were acquitted, right, by the Supreme Court. So in essence, in the last 15 years, our legal system, our judiciary, has confirmed only about 4.5% of the death sentences given. Right? Now you might think, when I usually talk about this, I sometimes get this strange reaction that clearly shows our system is working. Actually, it shows quite the contrary. That the system is completely broken at the bottom, right? At the bottom, you have 95% of people being unnecessarily sent to death row, right? And I think that is unacceptable for any system, right? For any criminal justice system, that kind of figure is just unacceptable. That kind of error is just not acceptable, right? And you have to understand that life on death row in an Indian prison is very, very different from life as a prisoner who's being asked to spend 10 years or 7 years or 15 years. Life on death row is very different, and I think we don't know these things. We don't think about these things when we debate the death penalty. Like in an Indian prison, death row prisoners across most jails in this country are kept together in one barrack. They are not allowed to interact with the general prison population. They are not allowed to take part in other festivities or functions of the jail. They are not allowed to work because they are considered high-risk prisoners under jail manuals. And therefore, all that they are left to do is to interact with other death row prisoners and contemplate their death every single day. And I think there's something particularly cruel about that, right? And particularly cruel when you look at it in the context that 95% of these people are unnecessarily kept like that, right? So I think we need to interrogate and open up more fronts of investigation, of understanding the death penalty in India. It is not just about, oh, should terrorists be hanged, should rapists be hanged, and we just get frustratingly caught down into this binary of, if it is a heinous crime, we must give the death penalty. There is so much more to the criminal justice system as to how you move from crime to punishment. And surprisingly for me, I think the moment you start talking of death penalty, everybody has this strange confidence in the criminal justice system. Suddenly we have faith in our police. Suddenly we are willing to ignore custodial torture. Suddenly we are willing to ignore custodial violence. We are willing to ignore prosecutorial misconduct. Suddenly we have the faith in the criminal justice system, that we have a criminal justice system that is capable of producing death sentences. Whereas in every other context, we know that our criminal justice system is broken and rotten, right? And it's surprising for me as to why we don't take that very same discussion into the context of the death penalty. In the context of death penalty, it's only about heinousness of the crime, right? Anyway, the 4.5% 1% is the national figure. I'm not going to get into the state figures where the story is much worse. Some states, especially the states with the most number of death row prisoners, do terribly on this 15-year study in sort of the period that we've looked at, 15-year period of death sentence cases. They do much worse than the national average. But anyway, I'm not going to get into that, and probably we can get into it during discussion. Now, these sort of procedural problems are not just, in that sense, with the trial courts, right? And there's very little focus on what the trial courts do. But anyway, in the Supreme Court, right, in January 2015, the Chief Justice and 2 other judges, on the same day, dismissed in limine appeals of 4 death row prisoners. What does in limine dismissal mean, right? For the lawyers amongst you, I suppose, will know what it means. But for the others, it basically means that the Supreme Court did not admit the appeals of 4 death row prisoners. It said, we do not want to hear your appeal. Conceded that they do not have a right to an appeal, but it is extremely rare for the Supreme Court to not hear a death row appeal. Right? There is something known as a special leave petition. You file a special leave petition which is asking the court to admit the appeal. Right? And here you have the Supreme Court not even willing to hear the appeal of 4 death row prisoners. Right? And this has been done only about 8 times in the last 15 years. Right? Now coming to our study of the last 2 years, which is based is an empirical study based on interviews of all these prisoners. There were 385 prisoners on death row during our study, of which we were given access to 373. Now, and again, we had to go to each state, negotiate permissions with each prison department, and anyway, that's a whole different story to be told on its own. Now, before I get into the socio-economic profile issues, I just want to give you a sense of for what can you get the death penalty in India, right? Just talking of central legislation, and not even talking state legislations, there are about 20 legislations under which you can get death. Of these, there are 13 homicide offenses, right? By homicide, I mean for causing loss of life, you can get death, right? There are 45 non-homicide offenses, right? There are 45 non-homicide offenses, right? That basically means that for not causing loss of life also, you can be given death. What are the most glaring examples of this? Waging war, right? Waging war under the Indian IPC, or under the Indian Penal Code, for waging war against the Indian state, you can be given death even though you have not caused death of any person. Then under the new 376E, that's used in the Shakti Mills case, again, a complete misuse of the provision, and I hope you will read about the case as to why it is a blatant misuse of 376E. Again, there, for the repeat offense of rape, even if you haven't caused death, you can be given death. Then it ranges to the ridiculous, right? Under security legislations, if a guard is sleeping at his post, what do? Sentence him to death. For destroying or causing harm to a pipeline, you can be given death. Because of course, I assume the whole national interest argument against it. Right? So it ranges up to the ridiculous for what we give death. Recently there was an anti-hijacking legislation which again provided for death. Right? So there is this entire, and why is this debate important between homicide and non-homicide, right? In various other retentionist jurisdictions, there is this issue of proportionality of punishment, right? That you can take life, right? If you have caused loss of life, right? And that's the context. You may disagree or agree, but I just want to place that before you. Now, who gets the death penalty, right? Without giving you specific numbers, there are a disproportionate number amongst these death row prisoners who are backward classes, scheduled castes, scheduled tribes, and religious minorities, right? They form a disproportionate number, right? A very high percentage are extremely poor, right? And most importantly, this entire idea that we are sentencing hardened criminals, we are sentencing people who cannot be reformed. These people must be eliminated from society, right? Just does not play out. And why does it not play out? In the figures, it does not play out because a very large proportion of them are first-time offenders, right? A very large proportion of them are first-time offenders, and even amongst the tiny percentage that are not first-time offenders, most of them have previous convictions for petty offenses, right? So this entire image that we have, that popular media builds around death row prisoners of these inherently evil individuals, just does not play out, right? What about educational profile, right? About 24% of them have never even entered school, right? Have never even gone to school for a single day. And the numbers just keep rising if you were to look at how many of them have completed school education, right? And amongst these people who have never gone to school or have not completed school education, there a very high percentage belong to scheduled castes or scheduled tribes, right? So there is, in that sense, and again, we've looked at what were the occupational profiles at the time of their arrest. All of this shows to severe marginalization, right? And people belonging to excluded groups, right? Groups that live on the margins, right? And I think we cannot ignore that, right? I guess we've all known this and we've had an intuitive sense of this for the longest time, but this study is important because it gives you an actual number for the first time, right? It provides that empirical proof, right, that the death penalty has a disparate impact. I'm not here suggesting, and there's no way for me to know that if a scheduled caste or a scheduled tribe accused appears in front of a judge, the judge looks at that person and discriminates actively. And that's not my point, right? There's no point, there's no way for us as researchers to establish that causality, right? But what we are saying is that certainly the death penalty seems to fall in a disparate manner on certain groups more than certain others, right? Now, in terms of legal assistance, very counterintuitive findings, right? We thought we would find many of them had legal aid lawyers, which didn't turn out to be true. A vast proportion of them had private lawyers, and it's not very difficult to see why. There's this inherent fear of the legal aid system, right? They feel that death is more or less assured if you get a legal aid lawyer, right? And therefore, many of them, despite being extremely poor, sell any little possessions that they have, they get into debt so that they can hire a private lawyer. And despite that, they hire private lawyers who are very much at the bottom of it. If you were to they pay them about 100 or 200 rupees per appearance, and you get legal representation only of that quality for that amount of money, right? And as a result of this, it is the number of times you've heard these accounts about how lawyers have never discussed these cases with their prisoners. They've never met the prisoner in jail. They never sat down with the prisoner anywhere and discussed the evidence that has been presented before them. Asked them to explain the prosecution evidence. So these are the kind of fundamental flaws that we're talking about. And when you have such fundamental fault lines in your criminal justice system, you cannot rely on the criminal justice system to sentence people to death, right? You might ask, then can we rely on this very same criminal justice system for other things? Obviously not, but I'm saying, as I said, my submission is that being on death row is a very, very different experience, right? It's a very, very different psychological journey within prison, right? Being on death row. Now, before I sort of wind up, I just want to talk about the Yaqub case and the involvement of the death penalty litigation clinic at NLU Delhi. I think it was sort of disheartening to see the level of public discourse on what was being argued over those 3 days, 3 or 4 days, right? The latest round of petitions were very simple, and my own anguish at what the court did arose out of the fact that there were very clear judgments. And I'm not here talking about did Yaqub Memon deserve the death sentence, or did he deserve to be sentenced to death for whatever he was convicted for, right? I am not on that. These two petitions over the last round were very, very narrow. One was that the death warrant was illegal, right? What is a death warrant? A death warrant is very simple. After all your legal options have been exhausted, the lowest court that sentenced you to death, in this case the Tata court in Mumbai, right, issues a death warrant. What is a death warrant? A death warrant basically is a warrant which sets your time, place and date for hanging. That's all it does, right? Everything else has been decided, that this person deserves a death sentence, this person must be hanged. All of that has been decided. A death warrant just decides these three things: place, time and date for hanging. Now, there was a judgment of the Supreme Court in May 2015 that we got to the Supreme Court in case of Shabnam and Salim versus the Union of India and versus Uttar Pradesh, where the court laid down that there is a procedure for issuing this death warrant. Right? There is a procedure. What is this procedure? It's nothing complicated. Simple rules of fairness. When issuing the death warrant, right, the prisoner has to be produced in court. Along with the prisoner's lawyers have to be informed. If the prisoner does not have a lawyer, legal aid lawyers have to be provided and they have to be present in court. And two other grounds, but in this case these are only three relevant grounds. So these are the three requirements that were there for issuing a valid death warrant. Now, the Attorney General and it was nobody's case in the latest round that this was followed. Nobody argued in court over those 3 days that this procedure was followed. Everyone was clear. Everyone was clear that Yaqub Memon was not produced before the Tata court for the death warrant. Everybody was also clear that his lawyers were not informed and neither was any lawyer present on behalf of Yaqub Memon for this death warrant. Right? And at the risk of repetition, I'm saying this has nothing to do with whether Yaqub Memon should get the death penalty or not. It's about the validity of his death warrant. The court could have easily said, according to our judgment in Shabnam, this death warrant is illegal. It is open to the state of Maharashtra to go and get another death warrant issued after following this procedure. Right? So it was not like if this death warrant was quashed, Yaqub Memon would not be hung. The state had the option to go and get another death warrant issued, but this time following the procedure laid down by the Supreme Court. Right? So that was the first writ petition which was dismissed on Wednesday evening. Then once that was there was a mercy petition that he had filed. So this was 29th evening. He had filed a mercy petition before the president on 28th, right? That is Tuesday night, right? This must be the quickest disposal of a mercy petition. In about 12 hours, the Ministry of Home Affairs had reached a conclusion, right? They had read about, I don't know, some 1,000, 2,000 pages and decided that they were going to recommend to the president that the mercy petition be rejected. The president acted with even more greater efficiency, right? Since we are all obsessed with efficiency, right? And in 2 hours, decided that he need not read the file or anything. Obviously, he couldn't have read the file. That it was enough to listen to Rajnath Singh, right? And said, okay, fine, I'm going to reject the mercy petition. So in about 24 hours, you have the Union Home Ministry deciding, having considered the file and said, no mercy, recommended to the president. The president has also rejected it. Okay, fine. I think there's great I think the court should have taken great umbrage at this. That how could you have decided a mercy petition in 24 hours? Right? It clearly shows non-application of mind by the executive. Right? Okay, let's assume that they are terribly fast readers in the Ministry of Home Affairs. Right? And that the president is, I don't know, a great scholar and is whatever. Let's assume that. By the Supreme Court's own judgment from January 2014, you have 14 days from the rejection of your mercy petition towards execution. Not only that, let's assume the court's argument that, oh, your first mercy petition was rejected in 2014, you had a year. Let's assume. The court itself has recognized a right of every death row prisoner to challenge the rejection of your mercy petition. Right? And this is a fundamental right under Article 21. And this right, there cannot be a limitation period, as the court seems to have imagined that there can be. There is no argument that you have. Now, if the police have tortured me 10 years back, the court can't say, oh, why didn't you come to us 10 years ago? That might be relevant for rent control or property or whatever. You can't say that when you're talking of fundamental rights in the Constitution. There is no concept of limitation for exercising and enforcing your fundamental rights. And this was the subject matter of the second petition that the court heard at, I don't know, I mean, I was sort of really surprised when I went back home that morning and all that was on the news was the celebration of the Supreme Court opening its doors at 3 a.m. I mean, I don't know, I really don't know what to say to that, right? Because the orders, the reason, and please read these two orders, the one that came on Wednesday evening and then the one that came on Thursday early morning. I really don't see how the court could have ignored its own judgments. And these are not judgments dating back 30, 40 years. These are judgments in the last 12 months, 18 months. What would have happened if he had given him 14 more days to challenge the mercy, rejection of the mercy? It is a constitutionally recognized right. It is not for something flippant you are giving him 14 days. You have recognized the right and you are giving him 14 days to exercise that right. And in so many cases you have emphatically declared as to how the Supreme Court of India will protect the rights of death row prisoners until the very last second. So what are we talking about? Right? So therefore that is, and so none of this, and I think as people who are involved in the case, I guess we also failed at some level to narrow this debate and we let it devolve into, did Yaqub Memon deserve the death sentence? While that was not the legal issue before the Supreme Court in those last two rounds of litigation, Monday to Thursday morning, right? And we really need to sit back and think how we let it happen. And let me be very clear, you might say, oh, as a lawyer you're nitpicking here. You're going on these little technicalities. These might be little technicalities for you. Right? At some point the Attorney General said, oh, what will happen? You might live for another 3 months. That's all. Very easy for the Attorney General to say. Right? But for that man on death row, every single day, every single minute counts. And I'm sorry, as a rule of law society, these are the inconveniences that you have to put up with. The legal system, we play by rules. And you cannot decide that these rules are inapplicable to people that you don't like. It's available to everyone. In that sense, democracy is a messy affair. Right? It's an inconvenient affair. And you can't wash your hands off it as and when you please. And that precisely, I think, and purely on those constitutional and legal grounds, I think we failed as a rule of law society in those forums. Thank you.